Anna, do you need to read a statement of necessity into the record?
Yes, I do, but I think Caitlin is going to call roll first.
And I just was trying to change it up a little bit, but if we have to do that.
If you want me to, I can read it.
No need to call roll if we don't agree on the statement of necessity.
Okay, I'll read the statement of necessity. This is an emergency electronic meeting of the Tennessee Real Estate Commission. Notice that this meeting was posted to the Commission's website on Monday, September 14th, 2020. As there is not a physical quorum present, a statement of necessity will be read into the record and filed with the Tennessee Secretary of State as required by statute. Pursuant to Tennessee Code Annotated Section 8-44-108B2, which states as if a physical quorum is not present at the location of a meeting of a governing body, then in order for a quorum of members to participate by electronic or other means of communication, the governing body must make a determination that a necessity exists. That determination must include a recitation of the facts and circumstances on which it was based. Further, Tennessee Code Annotated Section 8-44-108A3 defines necessity as matters to be considered by the governing body at that meeting require timely action by the body, that physical presence by a quorum of the members is not practical within the period of time requiring action, and that participation by a quorum of members by electronic or other means of communication is necessary. As stated, this is an emergency meeting of the Tennessee Real Estate Commission that is being held via Cisco WebEx. The purpose of this meeting with members attending by Cisco WebEx is to discuss the summary suspension decision from the September 9th, 2020 meeting. Furthermore, it is necessary for this meeting to be held electronically in accordance with Executive Order Number 16, issued by Governor Bill Lee on March 20th, 2020, further extended by Executive Order Number 60, issued on August 28th, 2020, to ensure government continues to function open and transparently during the COVID-19 emergency, while taking appropriate measures to protect the health and safety of citizens and government officials. Voting will be conducted by roll call.
Okay, thank you, Anna. Caitlin, I'm going to try this, but I think you can call the roll and people can vote on the statement of necessity at the same time. So they could say here and yes, or present and yes. What do you think about that?
Anna, thumbs up or thumbs down?
It's okay.
Okay, here we go. Commissioner Joe.
Let me say this. If you're in favor of the statement of necessity, after indicating you're present, vote yes. If you're opposed, vote no. Okay, Caitlin.
Okay. Commissioner Joe Begley.
Here, yes.
Yes. Okay, Commissioner Jeff Diaz.
Here and yes.
Commissioner DJ Ferris.
Here, yes.
Vice Chair Marcia Franks.
Here, yes.
Commissioner Steve Gwynn.
Here, yes.
Commissioner John Moffitt.
Here, yes.
Commissioner Joan Smith.
Here and yes.
Commissioner Stacy Torbett.
Here, yes.
Okay, Chairman John Grease.
Here and yes. Okay, we've got one item on the agenda today. At our September 9th meeting, you may recall this commission passed a motion to summarily suspend the license of a certain licensee. Following that decision, legal apparently huddled and has some additional thoughts about what we did and maybe some better ways to go, at least perhaps in their opinion. So I think Shalene is speaking for legal. Is that right, Shalene?
Sorry about that. Yes, sir, I will be speaking to that. Good morning, Commission members. This is Shalena Brown. We are here to discuss complaint 2018073-421. This respondent has been licensed as a principal broker since 2005. In August 2019, the respondent notified us of the conviction pursuant to Tennessee Code 62-13-312F. This was related to a felony concerning a tax preparation business previously owned by the respondent. The respondent served a federal prison sentence in 2018 and thereafter had a 1-year probationary period, which was concluded on December 10th, 2019. Initially, when this was presented to the commission, the commission had voted that the respondent's license be revoked. I have presented new information that the prison sentence had been concluded and the probationary period had also been completed and the restitution was being paid. Now, based on the fact that the respondent previously requested an informal appearance before this commission and has requested to address the commission concerning the circumstances surrounding this conviction, and the respondent does maintain that the respondent meets all the qualifications and prerequisites for licensure with this commission. The time period that has passed since the conviction is over 1 year. It's in fact
my
almost
screen is
2
frozen
years.
up. Is it just me?
I'm sorry?
Okay. Thank you. I'll keep up.
Okay.
Go ahead, Shalene. I'm
Due to
sorry.
the ti- Okay, due to the time period that has passed since the conviction, there's no immediate harm to the public at present. So I would recommend that we do not proceed with the summary suspension and allow this respondent to informally appear before this commission to address the conviction. Also, this commission has previously allowed informal appearances concerning convictions in the past, and I would suggest that the commission allow this respondent to appear also for that reason.
All right, commissioners, I hope you can hear me. I can't see you. My screen is frozen up. So legal would like to recommends that this licensee come before commission to make her case in an informal setting. And maybe after she does, we'll give her a blessing and wish her well in the real estate world. However, if she does come before the commission in an informal hearing, and after hearing her or him, we decide that she needs to show up in front of us with a judge and a court reporter and go through the formal hearings mechanism, it'd be hard for us to do that because we've already learned or heard most of the facts in an informal setting. So I would guess in a case like that, then the hearing would go before an administrative law judge without commission. The judge would make the decision. So as we talk through this, you've got a couple decisions to make. One, do you want to rescind the motion, rescind the action we took regarding summary suspension? And two, if you do want to do that, then what do you want to do next? Do you want to have her come before us as legal recommends to make her case? Or would you like legal just to schedule a formal hearing so that we can hear it as a body in a formal setting? So that's kind of how I see what we've got in front of us today. And I'll open it up for discussion. Marcia, and I can't see you all, so you're going to have to let me know if you want to speak.
Okay. Well, there's a big elephant in this room in that council at our last meeting told us who this person was. And my antenna went up when Ms. Matlock told us that the person is already licensed. So while I was sitting there, I checked Tennessee License Verify, and in fact, this person is listed as principal broker of this real estate company. So there's something that has fallen through the cracks on this. I'm not sure what, but with that information, I also Googled this person, and I don't think that the commission is being given all of the information, or since the attorneys have changed from the ones who originally presented it to us, that maybe they don't even have the full picture about it. I will say, when we met to discuss this in the beginning, the only ones from this commission now that were at that hearing was John Grease, Jeff Diaz, and myself. But the other commissioners were Austin McMillan, who is an attorney, Fontaine Taylor, Diane Hills, Bobby Wood, and Gary Bloom. And I can tell you, Austin, Fontaine, Diane, Bobby, and Gary were very good commissioners. They heard all of they didn't even hear all the information that we now have since council has given us that information. But I know we had a thoroughly well thought out discussion about it. This is not a case of somebody made one mistake. This mistake went on. She pled guilty to helping clients. What she was doing was she had,
Marcia.
yes.
I'm sorry to interrupt you, but I want to make sure we don't get, if we do go to an informal hearing or a formal hearing, it's probably best that most people don't know the facts of the case so they can get a picture in person. I'm not trying to slow you down.
In order for me to prove to the commission that in fact this person is an immediate threat to the public, that's where I was going with this information. Let me just say this then. This person had pled guilty to many counts, but did obviously a plea deal, so there was only one on her record. And it was something that went on for 5 years, many cases. So it goes to this person was went to federal prison because of this, I would say this. We were sure that we did the right thing, and now that I know the information that I know, I'm even more positive that this person is a threat. They are a principal broker of a real estate company. You can look on their website. They're still a realtor on that company's website. And I just think because this person did get out of prison in 2018, in December of 2018, and served her 1 year probation, which ended December 2019. So this person has not even been off of probation for a year yet.
Martha, can I chime in on a couple of things
Okay.
that you said? So a couple items. One, the reason that this licensee was able to renew was because they renewed prior to ever being presented to the commission. So they renewed in January of 2019, and we can't hold back that renewal on a pending complaint when there's been no action taken at that time. The other thing I wanted to mention is she's actually not a principal broker. I just pulled her up in the system. She has moved firms and is now under a principal broker. So she's not the principal broker of a firm.
Well, Caitlin, I have it right here from this morning, and it shows that she is.
Well, I have it from our core licensing system that she's not.
So how long does it take to get in the system?
Well, let me check verify and see the last time that it updated. But in core, and I can check when she officially transferred, but she is not the principal broker.
But what is she's a broker though, right? She still has her
She
broker's
is a
license.
broker, but she's not over a firm.
So she could go today and become a principal broker somewhere.
She could. I just wanted to state the facts that she's not one now. The other thing is the reason summary suspension is not appropriate is if that was something that the commission wanted to do, we should have probably done it over a year ago. It's now been, a year and 7 months.
And why is that, Caitlin? Why did we not do something about it?
I mean, I think it would be silly not to say that this one has fallen through the cracks and that this should have gone sooner to a formal hearing or action should have been taken sooner. There's no denying that. But I think summary suspension is only meant for, we're supposed to get a complaint in and we're supposed to do a summary suspension within a short amount of time. It is supposed to be a complete immediate threat. So given the facts of this, that it has gone on for this amount of time, that doesn't make sense. And it's
Yeah, but what does make sense, Caitlin, is that our council, when this was presented to us, recommended that we either downgrade them to an affiliate or revoke. And we chose to revoke because of the seriousness of the crimes. And this person has still not made full restitution. And this has to do with money that was stolen. Regardless of the time, she's lucky she got to keep her broker's license up until today. And we've made a mistake and we need to correct it because she can be out today doing her real estate.
And I don't think anybody's saying that we can't move forward with either bringing her in front of the commission, which would be next month. It would be in October.
So that gives her another month of opportunity to steal.
Or also moving forward with the hearing. Those are the two options that the department's recommending and that our legal counsel is recommending based on the time frame and given the facts that they have. They have both facts of the case.
Also, let me just add, if the commission is aware of the identity of this individual, this matter will have to be heard by an administrative law judge in a formal hearing setting. Of course, you can still hear from her informally, but based on the fact that there's been some background reviewed about her and some other searches about her, this will have to be heard before an independent administrative law judge sitting alone.
And Shalina, you gave us that information.
Yes, and that was an inadvertent error, and it was immediately removed, and only the last name happened to be in the where you present information. So in light of that,
there's only one person. There's only one person with that last name that has a license also.
Okay, and since there was additional information researched about her, independent of the, what was presented in the legal report, we would have to bring this before an administrative law judge to allow this respondent due process. Are you
saying that we do not, as commissioners, have the right to look at the Tennessee Verify to verify if this person, it was Anna Matlock who said this person is licensed. And so I would have been derelict with that information to not look it up and found that it was true.
Well, you could look up by the license number, but you should not have found out the identity because these complaints are presented anonymously to all boards and commissions when they're reviewed.
I understand, but because of the seriousness and the immediate threat to the public, I don't see a reason to, here's what I think needs to happen is that the revoke needs to stay in place. And if they want to take it further, then they need to go through the proper channels of taking it further instead of coming before us now, having a broker's license and now saying something. They knew it was not right also. They knew it before we knew it.
Shalina.
Yes, sir.
Okay, so I would argue that the commission at this point does not need to excuse itself from a hearing. Perhaps Ms. Franks does, based on what you said. But generally, all this commission has done is heard some comments from Marcia about it. We have no knowledge otherwise, especially to Marcia's point that only 3 originally were sat in on this. It wasn't even a formal hearing. It was an offer to a civil penalty to revoke the license, which she never accepted, or he never accepted. So, what do you think about that argument that you can't excuse us all just because one knows something?
And I'm happy to recuse myself if that's what's needed.
I did want to just speak to that. I know, we do the orientation and you're a new commissioner and it is at the beginning of your start. And Marcia, it's probably been, over 5 years. I mean, almost probably 8 years since you have done your orientation, but we do in the orientation ask that commissioners review the documents provided to them and not do outside research. And I'm sorry, I can't hear you.
Yeah, no one ever told me that. And we've been doing that this whole time for years. And nobody's ever told us not to.
Okay, well,
And
I can
at this
review,
meeting
I can
also-
send the board member orientation manual again and just sort of highlight where that is discussed. But it is something that we say is that you should base it on the facts presented
Okay,
to you.
Denard Mickens was he was the chief counsel at that time, and he was also present when we had the hearing. And I think had he thought that we were acting inappropriately by revoking her, that he would have said something. We actually had like 4 or 5 of the state lawyers there with us when we revoked it.
I don't think anybody's saying that decision was inappropriate. What we're saying
now, no, they're saying that this person is not a threat to the public, and I think that they still are because of their lengthy. It's not one time that something happened.
what we're saying is that the summary suspension option is not the right avenue. We're not saying the past decision was, not okay. Joe, is that you wanted to say something?
So if you're saying that we can get a hearing lined up by October, can we file an injunction that they don't do any business for the next 3 weeks, and then so they can't do any business for 3 weeks, and then we have this hearing?
No, we can't do an injunction. And as far as getting a hearing lined up, we cannot have a formal hearing in October, but if you'd like to informally hear from the respondent, we can arrange for that to happen.
But this person remains revoked. If it slipped through and she was able to get a license, it remains that she is revoked because we revoked her.
She would still have to go through a formal hearing process in order for that revocation vote that was made by the commission to be instituted. She has not been revoked. Her license is still valid, and until a formal hearing is held.
Incorrectly.
Well, let me say this, Shalena. At the moment, it's been suspended.
No, it has not been suspended as of yet until the summary suspension hearing is held, which I'm recommending that we do not do, or we have a formal hearing. But I'm requesting that you allow her to informally appear to further discuss the facts and the situation in the respondent's situation.
Once that occurs, then there's no way any member of the commission can sit and make a decision in a formal hearing. We at that point know too much. Correct?
Yes, that's correct.
I have a question.
Yes.
Since I'm still relatively new, how come there's no way to rectify a situation where something clearly has fallen through the cracks? If a decision was made, I don't have the document pulled up. So when was this originally decided upon by the commission?
I'm
2017.
sorry.
When was the original grievance filed? I guess my question is, if the commission made a decision that wasn't followed up on, then why is the responsibility back on the commission to figure out how to fix that? Does that make sense?
The complaint was brought to the commission for review in March of 2019. The respondent informed the commission of the conviction under the statute in August of 2018.
And so the
So
commission
the respondent
the commission at the time decided what was the original decision. I'm sorry, but I don't have everything pulled up here, so I don't want to get confused. But the original decision of the commission in March of 2019 was what?
was to revoke the respondent.
And Stacy, I was just going to add in, typically what would happen is after the commission's decision, that respondent would have the opportunity to agree. An order would be sent and they would have the opportunity to review the order and agree with it. And that every complaint that discipline is issued is handled. So any complaint that y'all see on a monthly basis, our legal counsel that results in discipline sends out an order for them to review and agree to. If they agree, then they pay any penalty or do any education, and then it's closed out within the time frame. If they don't agree to it, then they have a certain period, and then it would move to the next stage of discipline, which would be a formal hearing, typically if the discipline is not agreed to. And so that's where we are with that step did not take place, and that's why we are where we are today.
The order wasn't sent?
No, the order was sent. It just wasn't agreed to, and then that next stage fell through the cracks. And it was not Sharina's case at that time. It was another legal counsel's case at that time. And so that's kind of where it fell through. And now, given the time frame, we're just presenting two other options to the commission.
Okay.
Mr. Chairman,
Yes.
this is Jeff. So
If
the
you-
order wasn't agreed to, so the natural next step would have been to schedule a formal hearing. Is that correct?
That is correct, yes.
Okay. Mr. Chairman, I make the motion that we rescind the summary order and schedule a formal hearing as soon as possible.
Okay, is there a second?
Second.
Thank you, Tracy. Stacy.
Question. Question.
Please.
What is the difference between, or is there a difference between revoking and suspension? And then the other question is, and I'm a little confused on the timing, but when did this person go and apply for a new license in this gap period of time, so that she filled out a form, and I don't know what the form says, or when you reapply for a license, what does it say on there about, are there any pending matters before the board or anything like that, so that she would have been out, or am I really confused on the sequence of events?
I can speak to that. She never lost her license. She had an active broker's license when she reached out to the commission in fall of 2018. And she
Okay.
reached out immediately following her conviction. And so she met the 60-day time frame that's outlined in the statute to notify the commission And at that time, she requested to come before the commission and sent a copy of the order from her case, and then also notified the commission that she would be unavailable for the next 90 days. So her license never lapsed. When we got that,
Lapsed.
yes, it never lapsed.
So she never signed anything in
But-
this
but, okay.
period of time?
So the renewal does have a question. Have you been convicted of anything within the last renewal period or within the last 60 days?
Yes.
And she answered that question honestly.
But we haven't seen that though, right?
Well, it's on her
was that-
renewal. It's on her renewal. And it's just a yes or no question on the renewal. And she answered that honestly. And then it was in line with what she submitted to the commission. She submitted a letter and a copy of her charges.
So back to my first question then on revoking versus suspension, is there a difference?
Yes, sir, there is a difference. The suspension is typically determined for a set period of time by the commission, and a revocation is a complete revocation of the license, meaning there's no license that exists.
So that if you want a new license, then you've got to go back and do everything all over again. It's like it never existed, correct?
Correct.
And we revoked, or the commission revoked her back in when?
They authorized a revocation, which means that the hearing, a formal hearing, allowing the respondent due process still has to occur. So even though the commission votes for a revocation, a formal contested case hearing still has to occur in order for that revocation to be reviewed and adjudicated on by the commission or an administrative law judge.
So basically, I mean, the way it appears that the planets lined up exactly right for us to get to where we are today. Is that kind of right? I mean, all these things had to happen in a sequence of events that we revoked. There was no hearing. I mean, all these different things happened to get to where we are right now. It seems very low probability, but in any event, I guess we are where we are.
So please remember, I cannot see you all, but let me just get us where I think we are at the moment. Jeff has made a motion that Stacy seconded that if passed would rescind our previous action regarding a summary suspension. And by the way, Shalina, I think that means that this licensee's license is suspended until we have a hearing, but I could be wrong, but I think that's what it means. If the motion passes, Jeff has asked for a hearing as soon as possible. Now, the question before we get to this vote is, if it's an informal hearing and we don't like what we hear, because now we've all been presented with details that normally would only be presented at a formal hearing. We've kind of disqualified ourselves from having a formal hearing, and it would have to be handled by an administrative law judge.
Excuse me, Chairman.
Yes.
I understood Commissioner Diaz to say move to a formal hearing as soon as possible, not an informal hearing.
Thank you. DJ, is that right, Jeff?
That's correct, Mr. Chairman. And
Okay,
I will just say, while I've got the air right now, if the individual has been requesting to come before the commission since the fall of 2018, and I think it's more than enough time has passed for that to occur. It's fall of 2020, so I support the motion as made. and I'll listen for more discussion.
Thank you, DJ. So, Shalina, how quickly could a formal hearing be scheduled?
I can file that immediately, and it can be set for the end of October. 30 days notice has to be provided to the respondent for a formal hearing.
So if this motion passes, the licensee is still an active licensee, free to conduct real estate business, with the understanding that we'll have a formal hearing. I don't know if we can do it in 30 days. So we got to get a judge lined up as well, correct?
Yes, we can arrange for a judge to be present for the hearing.
I have a question.
Please, go ahead.
So if we go ahead with the summary suspension, what's the downside to that?
Well, in light of the time that's passed, I'm recommending that we do not proceed with the summary suspension, and that should have, as Caitlin had mentioned, that should have been done last year when this occurred. So the downside is the timing is just not appropriate for us to have a summary suspension.
What I'm saying, Shalina, is it going to help their case at the formal hearing or the informal hearing, or is it going to be a black eye on our part? Because we, as a new commission member, I have a lot of respect for Marcia and John, and Marcia's pretty adamant that we haven't seen anything that we understand that the timeline is different because they've gotten out of jail. But if you were a threat a year ago, we haven't been presented any new evidence that says their character or their anything's we haven't been presented any evidence that shows that if they were a threat 12 months ago, they're not still a threat to the public today. So I don't understand why, just because something slipped through the cracks, that they're not still the same person they were 12 months ago. Is that right, Marcia?
I've got a question.
Please keep in mind that this was a conviction based on a different business, unrelated to real estate. It was a tax preparation business, and I understand that it's still a conviction. However, it was not related in the practice of real estate.
Marcia, you're on mute. Marcia, you're on mute.
It doesn't matter. She has a felony. And here's why we revoked her. And I want to read it to you. It's 6213-312 B12. The commission shall have the power to refuse a license for cause or to suspend or revoke a license where it has been obtained by false representation or by fraudulent act or conduct, or where a licensee in performing or attempting to perform any of the acts mentioned herein is found guilty of being convicted in a court of competent jurisdiction of this or any other state or federal court of forgery, embezzlement, obtaining money under false pretenses, robbery, larceny, extortion, conspiracy to defraud, or any crime or any similar offense or offenses, or pleading guilty or nolo contendere to any such offense. And we know that she pled guilty. So, I mean, this is what the law tells us that we have the right to do. I disagree with our counsel that we don't have the right to maintain the revocation. I think it's unfair that you all have not heard all of the information like some of us have. And that's the reason we revoked this person.
I'm not saying that the commission does not have a right to proceed with the revocation. That's not at all what I'm suggesting.
Can I ask a question?
Yes.
I think you have two parts to your motion.
Yes.
Could you repeat that one more time? One of them was a formal hearing. What was the other part?
The first part of the motion was to rescind our previous action related to this licensee.
Okay.
Just rescind the summary suspension.
Okay. And am I clear that she is an active realtor or real estate agent during this period of time? Is that correct? Yes. And there's nothing we can do during this period of time. Is that correct? Is that what I'm hearing counsel say?
Unless the revocation remains in place, there's nothing we can do.
Okay, just so I'm clear. All right, thank you.
Revocation, let me just clarify quickly.
Yes.
The revocation that was voted on the first time the commission heard this is still out there. That discipline is still out there. It's just pending, essentially. I'm not using the correct legal term, but what we're saying today is nothing to do with the revocation. It's that a summary suspension is not the right course of action given the time.
So, Caitlin, if we move forward, we have a revocation. Nothing's changed about that. We have a revocation. The next thing is to have, if she disagrees and doesn't sign that revocation, then she can have a formal hearing.
Correct.
So if she wants to have a formal hearing before the commission, then maybe that's what needs to take place. I see no reason to give her any special treatment by allowing her to come speak before the commission in a formal setting.
So the motion on the table is exactly that. It would be the revocation would stand and that Shalina would move forward with filing it. And earliest case, it could be at the end of October, assuming that the commission wanted to proceed with this outside of their normal commission meeting day.
Okay, Shalina, one more question. Two questions, actually. Is it your opinion, Shalina, that commission is disqualified from hearing this case in a formal hearing setting because too much information has been passed out?
Yes.
That's your opinion.
So again, it's our counsel that messed us up.
It's not Shalina necessarily, but.
No, Shalina gave us the person's name.
Well, only you picked up on it, I think, which is
No, because Anna Matlock told us she is still licensed. She looked it up also.
Well,
that information is provided on the legal report.
We needed an emergency hearing. That's why we needed an emergency hearing, because we thought that she was still a principal broker.
Commissioner Fairfield, for the record, I don't know who this individual is. I know the name was talked about in the September meeting, but I did not look at anything further. So I'm ignorant largely of what's going on. And I got a question. Is there a difference? I'm following you about the summary suspension and how the time has elapsed and how you're recommending us not to do that. Explain to me, I've got two questions. Explain to me who would be in the formal hearing if all of us are accused. Second question is, prior to coming on this call this morning, I was feeling that I thought I wanted to hear more from this person. I did not think she was an imminent threat personally. I understand there was a serious conviction on her record, but how does this differ from a violent felony offense to a non-violent? That makes sense. I know.
Okay, so if the commission did not hear this matter, it would be heard by an administrative law judge who is fully versed in the laws and rules of the commission and could properly decide the matter. There would really not be an issue with the commission not hearing this matter. I know the commission typically does hear these matters, but in this situation, if an ALJ were to hear the matter, there would not be an issue. And as to your second question, this is a non-violent offense. It was a financial crime. And I would just like to, reiterate that it was related to a tax preparation business previously owned by the respondent.
Thank you.
Shalina, the quickest way to get this licensee in front of us is through this summary suspension mechanism. Don't you agree?
No, not necessarily, because after the summary suspension is done, then a full formal hearing is still required. So I would suggest that the full formal hearing would be the best option in this situation.
I thought with the summary suspension, the license is suspended, and almost immediately a meeting is scheduled with the licensee to show cause why it shouldn't remain in effect.
The requirement is that the formal hearing take place within a reasonable amount of time. It's usually not necessarily immediately following a summary suspension.
Yeah. All right. So let's get back to the motion.
So is there nothing that can happen if somebody wants to have a formal hearing and we have suspended or revoked or whatever to keep them from practicing until they have a formal hearing? So if somebody's license is revoked or suspended in 2018 and they don't get a formal hearing for who knows how long, they can continue to practice. There's no consequence at all.
Under the law, the respondent has a property interest in that license, and it is required that they be given due process and a formal hearing take place in order for the commission to remove that license from the licensee. We can't just, determine a license should be revoked or suspended without giving an individual due process.
So this individual has played the commission. We have been played. It fell through the cracks. This person knew it all along and continues on, got her picture on a website. So I feel like we've been played, and I see no reason for the revocation to not stand. And if she doesn't agree to that, then let her take it to a hearing. And that's what normally happens. We don't normally, instead of having a formal hearing, let them come in any other, it shouldn't have come before us now even.
Mr. Chairman,
this is Jeff.
Who's first?
Go ahead, Steve.
So if my understanding is correct, then we had a deal we revoked her license and the ball was in her court to come back to us for a hearing, which never happened. So we muddied the water by going in with this summary suspension when we had let's call it an offer on the table or a motion, a revocation that had not been followed through on. So if we go and undo the summary suspension, then we're back to the revocation, correct? And is the ball not in her court to come to us as opposed to us go to her? Meaning, if we say, okay, the summary suspension will reverse that decision, now we're back to the revocation, and it's up to you to come to us. We don't go to her. Is that not right, or is that wrong?
No, that is correct. We will set the matter for a formal hearing. It would be incumbent upon the commission to set the formal hearing, and then the respondent would proceed.
So is there a way for us to, I don't know if you call it notify the public or whatever, that basically there's a licensee out here who we have revoked her license, yet it has not been terminated because we haven't heard it yet? Or is that there's no?
Yeah, you don't do that, Steve. It's
Okay, I didn't. All right, I didn't think so.
we made an offer. She or he didn't agree to it, and what should have happened well before now is a formal
Right.
hearing should have been scheduled. And it's been a just pure particular irritant to me that we have had very few, if any, formal hearings in the time period since this occurred. And we need to get those things going, but that's another story.
Can we review Jeff's motion one more time?
Jeff, I'm going to state it and you tell me if it's correct.
Yes, sir.
The motion offered by Jeff Diaz and seconded by Stacy Torbett, if passed, would rescind the previous action this commission took on September 9th regarding suspension of this licensee's license and call for a formal hearing before commission as quickly as possible.
A formal hearing to hear what? The revocation?
At that point, the case that the commission heard back in 2018 or 19, whatever it was, would be fleshed out by the state's attorneys and defended or explained by the licensees or respondents' attorneys.
And Steve, the full authority of the commission from assessing a fine all the way up to revocation would be available in that hearing. Mr. Chairman, can I say something else, please? This is Jeff.
Absolutely.
I just want to say two things. This licensee would not be the first felon to come before the commission to defend their license or to apply for one. We've considered many applicants under the Fresh Start Act to allow them to get a license. Their reputation and the consumer has every opportunity to research a licensee and decide if they want to do business with that licensee. Second, I would say that the formal hearing is the best venue because if we do an informal hearing first, I think council is correct. We'll disqualify ourselves from a formal hearing, and I just think we need to retain our authority in this matter so we can decide through a formal hearing. Thank you, Mr. Chairman. I call the question.
Okay, thank you, Jeff. Is there an objection to the call?
I have a question.
Wait. Let me see. You want to object to the call? Is that Joe?
No, I just wanted to follow up on Jeff's comment right now. I think Shalina's saying we're already disqualified. Do you think we're already disqualified, or only if we have the informal hearing we're disqualified?
If you are familiar with this respondent or have reviewed any details concerning the identity of the respondent, yes, you would be disqualified. If an informal hearing is held, then the entire commission would be disqualified, and this would be heard before an administrative law judge who, as I mentioned, is very well versed in the laws and rules of the Tennessee Real Estate Commission and could properly adjudicate the matter.
And we were all given the information in our legal documents for this last month, the name of the person. So that disqualifies every single person then.
Marcia, I would argue that that's not the case.
I hope not.
I'm going to take the position that commission with maybe, you've clearly researched it to your credit, but that probably disqualified you based on what Shalina just said. But other commissioners may have as well. And at that hearing, a judge is going to say, do you have any particular knowledge about this case or this respondent that might cause you to be influenced in your decision? If the judge asks you that question, Marcia, you probably have to say yes and have to recuse yourself. If other commissioners also have information, they're also going to be required to disqualify themselves. I don't like stating that, but I think that's the fact of the matter. That's what the judge is going to ask.
And I take offense to it because there was a decision made, a proper decision was made, and this was muddied not by the commission but by our council. And I take offense to that. I don't know what's going to happen with this. Today, this woman still has her license. We typically, when we have somebody that's had a felony, we usually try to wait. They need to be off of their probation for 2 years. That's not even happened yet.
Okay. Other comments?
Commissioner Ferris here, and
Just in response, Mr. Chairman, the 2-year waiting period is kind of moot now because of the Fresh Start Act.
Yes. DJ?
no, I was gonna agree to that, Commissioner Diaz, and if this did fall through the cracks from council authorized by the state of Tennessee, all the more reason for this individual to have the opportunity to come before a formal hearing and speak for themselves.
Other comments?
Mr. Chairman, I haven't heard an objection to calling the question.
I know, I kind of let that slip. I'm going to say that. I'm sorry.
Johnson here. I just wanted to weigh in quickly. I appreciated Commissioner Diaz's motion. I think it's the correct course of action. There are many problems in this, right? We all acknowledge that, but we have to take the things that are in front of us today and not worry as much at the moment about what may or may not have happened over the past year or two. You have a person here who properly identified on the renewal application that there had been an issue, and no fault of hers whatsoever. And I'm not pointing fingers here. Nothing happened. She served her time. We know that in this probationary period that she has been in full compliance. I think it would be very difficult for us at this point to take away her livelihood. It certainly flies in the face of the spirit, if not the letter of the Fresh Start Act at this point. Now, the problems that have led us here today, I will get to the bottom of and figure out what happened, because we don't, none of us want this to happen again, right? I mean, it's just not acceptable. But we're here today, and in this particular issue, I think Commissioner Diaz's motion is the appropriate one as we begin to move forward. We can have we can all talk. I'd be happy to take anybody's phone call and chat about things. But I think that's where we find ourselves today. And I think that, again, Commissioner Diaz's wisdom here in presenting that motion is the correct way and the correct path forward for all parties considered. I'll leave it there. I thank you for letting me chime in. I just want to make sure that we properly kind of put the light on that.
All right, Toby, thank you. Jeff, your call for the question still stays, although the chair is paying no attention to it, apparently. Is there other, without objection, I'm ready to get the roll called and see how this vote goes. Any objection?
Can you review exactly what the vote is? All
right, the motion is a two-part motion. One, to rescind the summary suspension that the commission passed September 9th. And the second is to schedule a formal hearing in front of commission as soon as possible, which can be no sooner than 30 days from now. If you're in favor of that motion, when your name is called, you'll vote aye or yes. If you're opposed, you'll vote no. Is that clear? I wish I could see you all. All right, Caitlin, let's do it.
I don't really know how you're talking, John. I don't even see your name on the screen.
I don't know what's going on. You know, but I can hear you all. There's this little thing that's spinning on my computer screen.
Okay, well, here we go. Commissioner Joe Begley.
Where'd you go, Joe?
Commissioner Joe Begley.
Yes.
Commissioner Jeff Diaz.
Yes.
Commissioner Jeff Diaz.
Yes.
Commissioner DJ Ferris.
Yes.
Vice Chair Martha Franks.
Yes.
Commissioner Steve Gwynn.
Yes.
Commissioner John Moffett,
Yes.
Commissioner Joan Smith,
Yes.
Commissioner Stacy Torbett,
Yes.
Chairman John Grease.
Yes. Okay, so the motion passes, which means that it's likely we'll have a special meeting sometime late in October. Is that correct, Shalina?
Yes, I will file this immediately.
All right. It could be virtual, it could be in person.
Let's hope that it's in person. Just please keep in mind too that I'm at the mercy of the Administrative Procedures Division to assign an administrative law judge to this matter. So just keep that in mind, but I will file this immediately.
Somebody in the legal department ought to call the Administrative Procedures Department and call in a favor or two. Let's get this one done. Is there any other business to come before the commission? If not, thanks for your participation. Hope you all have a great weekend and stay tuned.
Thank you.
Thank you.
Everybody,
Thank you,
be
everyone.
safe.
Thank you.